Alright, y'all, this is a very important video. I'm going to tell you how Gwen and her husband inherited a house and they found out they only technically owned half of the property. I'm also going to tell you how, if you inherited a property with your siblings, how to buy out your other siblings correctly. Let's get started. Alright, y'all, if you just inherited a home, if you have a fixer-upper, if you have a house you don't know what to do with, send it our way. We would love to give you a cash offer. So let's talk about Gwen and her husband. When we met them, they had spent $8,000 plus on attorneys trying to figure out how to transfer the property to their name. Okay, they were the rightful heirs of the property, but there were other heirs involved, other siblings, other cousins. So they had to hire an attorney, and they had spent over $8,000. Okay, so I'm going to break down the chain of title. Let me know if you have something similar to this. Comment below. Okay, so their great-grandparents were married. Okay, husband and wife, and they bought this property together. Now, the dad died first, but he did not have a will. Then the mom died, and she had a will that specifically stated that the house goes to her disabled daughter. Okay, because her disabled daughter could not work, so she wanted the house and the inheritance to go to the disabled daughter. Now, one of the siblings, who seemed to be in charge of all the siblings, usually have a sibling like that, maybe the most responsible or the most successful, whatever the case, he was the executor of the estate. And the will also said the executor has discretion to decide what happens with the estate. So that's very fuzzy language, okay? Because it says the disabled daughter gets it, but it also says the executor has discretion. So what he decided to do, because the disabled daughter actually passed away, what he decided to do is he bought out all the other heirs. There were about 8 siblings. He bought them all out. He got an attorney, and he technically owned the property. So he thought he did. Okay, so he thought he owned the property. He passed away, and in his will it said his property goes to his wife. This was our seller. So his wife was our seller. Okay, so let me review it so you guys, I want to make sure you guys are following along. So great grandmother and great grandfather bought a property together. The dad died, did not have a will. The mom died, she did have a will. The great grandmother died, she did have a will. So the will said the property goes to the disabled daughter. The disabled daughter passed away, and the executor of the estate, one of the brothers, one of the siblings, bought out all the other heirs. So to a normal person like us, this seems very, very straightforward, right? Grandma and grandfather bought a property together. Grandpa died. The property's left to the mother. The mother passes away. She has a will. She leaves it to her kids. To the disabled kid dies. The brother, the executor of the estate, bought out all the other siblings, so technically he owned the property. He had a will that gives it to his wife, which is our seller, so technically his wife owned the property and she could sell it to us easily. That was not the case. So the issue was that her great-grandfather, because he didn't have a will, the property goes to the kids that he had. So technically they have a share of the property and they passed away. Okay, so now you got to follow that chain of title. They passed away, so it goes to their kids, and so on and so forth. In my opinion, guys, I'm not an attorney, so the attorney that did the will for the great-grandmother, he should have caught that. Okay, because he didn't caught that, it was too late. You know, years have passed, and all these people are dead now, and you got to follow the chain of title. There's nothing we could do. We even had to go to 2 different title companies. Now, I have relationships with these title companies. They went up to bat for me. We actually ended up going to 3 different title companies, and none of them could figure it out. Because we had a relationship with them, they charge us on the back end, meaning they charge us at closing. So when you're closing on the property, there's usually a closing statement. Let's say the property is $200,000. So the attorney is going to charge, let's say, $2,500, and it comes out of the proceeds of the property. So that's how you can save some money. So this couple, they had spent over $8,000 because they went to an attorney. They just went to a regular real estate attorney. If you want to save money on going through the title issues, probate, doing an affidavit of heirship for your family, and you're going to sell the property anyway, go through a title company. The benefit of going through a title company is they're going to insure the title. Insuring the title means if they make any mistakes, you're going to get the value of that insurance policy back. Okay, so you're not fresh out of luck. It happens all the time. The thing about the law, it's an interpretation. That's why you can go to court and two different lawyers are fighting over the same case because they interpret the law differently, and that's why you have a judge. Okay? So, speaking of Gwen and her family, a suggestion that the title company made is, well, we can go in front of a judge and we can determine who the rightful heirs are. But the challenge with that is they had to get a sign-off from the other heirs that did not get along with them. So at the end of the day, they only owned half of the property. So our investor was able to purchase half of the property at, unfortunately, a significant discount. There was still enough equity in the property that they were able to get a substantial amount of money, that they were still able to reach their goals, but technically they only owned half of the property. Very big lesson here. If you are going to have a will, if you're going to have an estate, if you're going to do an affidavit of heirship and you're going to hire a real estate attorney, I recommend you go through a title company. They have attorneys there, or you can go through a real estate attorney that's not a title company. Just make sure they have insurance on that title. Buy an insurance policy, because the worst thing that could happen is your kids, they think they own the property, and let's say 100 years down the line, they're ready to sell that property, but the will was not done correctly, and they find out they only own half of the property, or someone else can claim rights to that property. How to buy your siblings out of the property. If, let's say, you just inherited the property, all three siblings inherited the property, let's say there's three of you, and let's say two of them would like to sell the property, but you want to keep the property, right? You know that your mother or grandmother wanted to keep the wealth in the family, and you wanted to keep the property. So the simple and most straightforward way is simply sign a purchase agreement, and have your siblings sell their portion to you, and sign a document that specifically states that they want no interest in the property. Make sure everything is documented. Do not do a quick claim deed where they just sign it over at the courthouse or at the county. Make sure you go through an attorney and you get a warranty deed, and make sure you fully own the property, and make sure there's insurance on that title. So that's the easiest and most straightforward way. The amount of money to give your siblings is you can simply determine it by knowing what the value of the property is, subtract what repairs you're going to need, and divide it by 3, and that's the portion that your siblings get. So let's say, for example, this is the fair way to do it. Let's say the property is worth $200,000 all fixed up. Let's say it needs $70,000 in repairs. So you're down to $120,000. That's what the value is before repairs. And let's say your siblings are okay with you making some profit with the repairs. But if not, $120,000 is divided in 3. Okay, if the property's worth $200,000 and it needs $70,000 in repairs, it's not fair that you're buying it for $200,000 because you're gonna have to put $70,000 into the property. Okay, so that's the fair way to split the proceeds of the property. Now, what can you do if you don't have any money to buy out your siblings? So there's 2 things you can do. The first thing you can do is, if you have good credit, you can get a loan from the bank, same scenario, and you literally get a loan on the property and you buy out your siblings from that portion. Basically, you're refinancing on the property. So that's the second way to do it. If you don't have any credit, There's another way you can do it. This is super, super risky. I don't recommend it at all. But what you can do is you can partner with an investor. And what the investor is going to do is they're going to buy out your siblings, right? So now they've bought out your siblings. Now you and the investor own it together. The investor is going to fix up the property, okay? And then in the meantime, while the investor is fixing up the property, let's say it's going to take 6 months, you fix your credit in that meantime so that when the house is all fixed up, there's more equity in the house. You're going to buy out the investor by getting a loan from the bank. Okay, I don't recommend that because you don't know who this investor is, and now you are co-owners of the property. At least your siblings, there's blood there, and you know your siblings, and I hope that your siblings would not screw you over.